We're back. I'm George Curtis. The program is It's Your Law. My guest is an old friend, Bill Gleisner. And Bill, at this particular stage of life where you've really attained a lot of recognition, good economic success, you've decided that you're going to run for office. I don't know who you got advice from, but tell us why.
Well, I did it for several reasons, but I think the best way to start is by emphasizing how important the Court of Appeals is. It's sort of an invisible court. People know about circuit courts where they go for traffic tickets or for civil trials or criminal proceedings. They see that on TV. They know about the Supreme Court. And the Court of Appeals is sort of invisible, but it's a very, very important court. There are 3,000 appeals last year to the Court of Appeals, and only a couple hundred of those made it to the Supreme Court. So for the 700 or so appeals in District 2, which comprises 12 counties, from Manitowoc over to Winnebago and down around Milwaukee, not including Milwaukee, to Kenosha, that means that this court, the Court of Appeals, is the court of last resort for many, many of the cases that get tried. And I was a candidate. I was an appointee applicant to the governor for appointment to this court. I was one of the finalists with my opponent, and it occurred to me that it was very important that the voters have a choice. And the person who I'm running against is I'm sure, an excellent lawyer and a fine person, but doesn't have the level of experience that I have with appellate work and with trial work. And I felt that the voters should have a choice as to whether they wanted my opponent or they wanted somebody who has more experience. And I felt that it was also important that the Court of Appeals function the way it was intended when it was founded in 1978. When it was founded in 1978, John Decker, the first Chief Judge of the Court of Appeals, made it clear, as did the legislature, that the Court of Appeals was to be an error-correcting court. The Court of Appeals is to be like a referee. It is to be the type of court that the Founding Fathers intended to be the honest broker in society. And we need people who really understand the law on that court. It's a difficult court because it is all about reading and writing. It's all about doing research, very little oral argument, very little contact with the public. But then that's kind of what I enjoy doing, because I've been doing it for many, many years. Researching and writing is something that I have a strong affinity for, and I have a strong belief in our judiciary, and I want to offer the voters of District 2 a choice.
Well, you're a scholar, Bill. I think everybody knows that you're a scholar and you've always wanted to get it right. And that's exactly the role of the Court of Appeals. And with all due respect to your opponent, she is the spouse of a former head of the Democratic Party in the state of Wisconsin, and she was appointed by Governor Doyle. I'm sure that they have a relationship, and there may be some payback there or not, and all of that's fine. That's exactly the way that system works, but that's why we have an election. That also is an error-correcting operation. And you're going to take your credentials, as you are today, to the electorate and say, I have had maybe 10 to 50 times the experience in writing appellate briefs, in arguing appellate cases, and in presenting scholarly studies on the law, and those are my qualifications. Also, I think it speaks volumes that your campaign managers, you've got one Democrat, you've got one Republican.
That's correct.
And a lot of support on both sides of the aisle.
I'm very blessed that way. I have been very blessed to be respected by trial lawyers and also defense lawyers and Republicans and Democrats. I'm very proud that I have been endorsed by folks like Dan Rotier on one hand and Bob Habish, and by people like Paul Bucher on the other hand. And I have wonderful friends who are both Republican and Democrat. It is the view of many of the lawyers who do trial work. And I've heard this often said, that they don't care whether a judge is, the judge in Wisconsin by law is supposed to be nonpartisan. but they don't care whether his background is conservative or liberal, as long as he calls it down the middle, as long as he's all about saying what the law is and pursuing what the law is. And I have had the good fortune, 160 lawyers and judges and law professors wrote letters of recommendation to Governor Doyle on my behalf. And they come from all over the spectrum. And I think that's the way it should be. I think a judge should be down the middle.
Now, when we try a case on the trial level, either to a jury and a judge or just to the judge, we make a record. There's a court reporter. If there are anybody who has any motions, they're in the record. If we have objections to the admissibility of evidence, they're in the record. And so there is that record. Then, if as a trial lawyer, I think it didn't come out right, that the court should have, for example, admitted some evidence I offered and the evidence was not admitted, what's my next step and how does it get to District 2 Appellate Court?
Every trial in the state of Wisconsin that culminates in a final judgment or a final order, the parties to that court, almost without exception, have the right of one appeal. And that right is to the Court of Appeals. So every, for example, trial that occurs in Winnebago County and ends in a final order or a final judgment, and sometimes it doesn't have to end in a final judgment. As you know, it can be something that is important that happens earlier in the trial, resulting in an interlocutory appeal, ends in the Court of Appeals. Everybody, almost everybody, has the right of a kick of a cat at that. But if they want to go to the Supreme Court, the next level, it has by invitation only by the Supreme Court, and they invite very few cases up.
That's right. If we don't like what the District 2 Appellate Court does, we can ask the Supreme Court to take the case, but the answer is no 8 out of 10 times, isn't it?
Oh, yes, sometimes 9 out of 10, depending on the type of case that we're talking about. And it is a very, very important court. The Court of Appeals, everybody who gets a verdict for or against them may end up in front of the Court of Appeals. And so this court is extremely vital and important.
So for most of us, as litigants or as counsel for litigants, we're pretty sure of 2 kicks at the cat.
Correct.
The trial level and the Court of Appeals level. The
Correct.
chances of getting before the Supremes are pretty slim.
Very slim.
So it's important that those people on the appellate court, District 2 or any other district, really call it fairly and are scholars and take it pretty seriously, and I know you would do exactly that.
I would indeed, and in fact, it's an error-correcting court, and that means that you, in order to correct errors, you have to be able to know the errors that have occurred. It's not a place to create law. I mean, it's not a place to experiment. You have to be able to look at a record, a cold record, and say, this happened or that happened, or I think this happened or that happened, and then correct it.
All right. We have to take our second break, Bill. Okay. When we come back, I'm going to ask you some more questions about the Court of Appeals, about how your campaign is going, and of course I'm always interested in this electronic production of evidence because I'm afraid it's something every lawyer is going to have to know, isn't it?
That is indeed.
We'll be right back. I want to make 2 points in closing. First of all, you've seen an example as to why judges should be elected by the people they serve and not appointed. Secondly, our recent experiences with million-dollar judicial races is an example of why these elections should be publicly financed, and so people can't buy elections. Give some thought to both of those points. Make your beliefs known to your elected representatives to the state legislature. But that's my opinion. I'm George Curtis.